Yes, yeah, Mr.
Indian time, not English time.
Yes, Mr. Salve.
Yes, Malad, may I quickly take the points one by one?
So, whatever Lordship decides will be of great significance.
Yes.
Malad, what? Let's take the first point which my learned friend started with.
Okay.
Let me take the point which my learned friend started with, came to in the middle, came to towards the end, and then it closed with. Retrospectivity. Malad, first of all, I had, Malad, in my opening, given your lordship a note. There is one case which I had missed, which explains it very well on what is retrospective. I'll not give a revised note, as my lady had said, dealing also with Mr. Rodgi's arguments, which I'll give by day after. But may I, my lord,
Yes.
give your lordship one case which explains it very well.
So we've given the citation.
2019, 19 SCC 529.
Court master.
These
all are given by.
My lord, I believe,
citation to the court staff.
I believe the citation has been given to the court master, my lord.
Yes.
You've given 3 book citations to.
Because while the book is being handed over, Malad, to save time, can I tell the court what my point is? A retrospective legislation is that which impairs past rights. Rights are between citizens and upon citizens. Between the state and the citizen, even a substantive law is considered to be retrospective if it confers new rights. And the classic example is the Probation of Offenders Act. I'll give you, your lordships have decided all this. But there is nothing substantive about 17A apart from repeating that 17A has a substantive element. I mean, a provision is either substantive or procedural. This is like saying boiling ice. I mean, it's either ice or it's boiling. A provision is either substantive or procedural. It either operates in the procedural field or it doesn't. A right of appeal, as the very expression is a right. And unless the appellate forum is abolished, a right of appeal continues.
But clear. Yes.
But I've got this iPad. I've got the genuine iPad.
It's okay. Yes.
Secondly, my lord, my learned friend hasn't even attempted to answer the point that a provision which draws on antecedent facts in its prospective operation is not retrospective. And there are so many. My lord, this 2019 is the case where, my lord, the court examined the conflicting views about the interest to small scale industries. If the book has not available, your lordship will turn straight.
It's now available.
I see. It doesn't matter.
It's available, sir.
No, it's available.
It's available.
So it's available now.
Paragraph 63.
Page 555. Page 555.
In all the judgments, it has been held that 93 Act is not retrospective. It is not contended before us any of the parties. If the 93 Act is retrospective, the judgments, as noticed, rightly hold that the right Act is not retrospective. In the opinion of Gowda J, although hold that the Act is not retrospective, he holds the Act retroactive. The word retroactive has been defined in blacks as follows: retroactive, extending in scope to matters that have occurred in the past. also termed retrospective, prospective, retro act. Two-judge bench of this court in State Bank Staff Union, Madras and Union of India had occasion to examine the concept of retroactive and retrospective. In para 2021, the judgment following has been laid down. Then it's a quotation. Judicial Dictionary by I.R. Bhattavath states that retrospective in use with reference to mean affecting an existing contract or reopening up of the past closed or completed transactions, or affecting accrued rights and remedies, or affecting procedure. Words and phrases defines retrospective or retroactive law as one which takes away or impairs vested or accrued rights acquired under existing law. A retroactive law takes away or impairs vested rights acquired under existing laws and creates a new obligation, a new duty, attaches a new disability in respect of transactions. In Advanced Lexicon by Ramnath Iyer, retroactive and retrospective, then my lord, those definitions are given exactly in the same terms. If your lordship sees the foot of page 557, sorry, 556, my mistake. There is a quotation, retrospective is somewhat ambiguous. And that good deal of confusion has been caused by the fact that it is used in more senses than one. In general, however, the courts regard as retrospective any statute which operates on cases or facts coming into existence before its commencement, in the sense that it affects, even if for the future only, the character or consequences of transactions previously entered into or past conduct. That a statute is not retrospective merely because it affects existing rights, nor is it retrospective merely because a part of the requisite for its action is drawn from a time antecedent to its passing. That's the principle, which I had not put in my note. This Halsbury says it, and your lordship cite it with approval. This is the starting point. My learned friend has not even addressed Chevret's case. And rightly so, because there is no answer. The 1964 Probation of Offenders Act, in 1964, your lordships held that this would apply.
Compilation 3.
This, my lord, is in compilation 3. Serial number 3. It's a judgment called Ratanlal and State of Punjab, AR 65 Supreme Court 444. I'll, my lord, only invite your lordship's attention to a specific passage. This judgment at page 50. Page 50 of the compilation. In fact, if I may read from page 49, it puts it very well. The first question is whether the High Court, acting under Section 11 of the Act, can exercise the power conferred on a court under Section 6. It is said that the jurisdiction of the High Court under 11.3. My Lord Justice Bose has it.
Yes. Yes.
Para 6. The first question is whether the High Court acting under 11 can exercise the power conferred under 6. It is said that the jurisdiction of the High Court under 11.3 is confined only to a case that has been brought to its file by appeal or revision, and therefore it can only exercise the jurisdiction as the trial court had. And in the present case, the trial court could not have made an order under 6 of the Act, as at the time it made the order, the Act had not been extended to Gurgaon. On this assumption, the argument proceeds, the Act should not be given a retrospective operation, as if so given, it would affect criminal liability of a person for an act committed by him before the Act came into operation. In support of this contention, a number of decisions bearing on the question of retroactivity of a statute in the context of vested rights have been cited. Every law that takes away or impairs a vested right is retrospective. Every ex post facto law is necessarily retrospective. In Article 20, no person can be convicted of any offense except for a violation of the law in force at the time of the commission of the act charged as an offense, nor be subjected to a penalty greater than what might have been inflicted under the law in force at the time of the commission of the offense. But an ex post facto law, which only mollifies the rigor of a criminal law, does not fall within that said prohibition. If a particular law makes a provision to that effect, though retrospective in operation, it will be valid. The question whether such law is retrospective, and if so, to what extent, depends upon the rules of interpretation of a particular statute having regard to the well-settled principles of construction. Maxwell on interpretation summarizes so and so. The tendency of modern decisions upon the whole is to narrow materially the difference between what is a strict and a beneficial construction. All statutes are construed with a more attentive regard to the language, and criminal statutes with a more rational regard to the aim and intention of the legislature than formerly. It is unquestionably right that the distinction should not be altogether erased from the judicial mind, for it is required by the spirit of our free institutions that the interpretation should be favorable to personal liberty. And this tendency is evinced in a certain reluctance to supply the defects of language or eke out the meaning of an obscure passage by strained or doubtful influences. The effect of the rule of strict construction might almost be summed up in the remark that when an equivocal word or ambiguous sentence leaves a reasonable doubt of its meaning, failing to solve out of its meaning with the canons of interpretations fail to solve, the benefit of the doubt should be given to the subject against the legislature, but it yields to the paramount rule that every statute is to be expounded according to the express manifest intention, and that all cases within the mischiefs aimed at it are, if the language permits it, to fall within its remedial influence. Let us now proceed to the present case. This is not an act which was not an offense before the act is made an offense, nor is this a case where under the act a punishment higher than that obtaining is imposed. It's an instance where neither the ingredients of the offense nor the limits of the sentence are disturbed, but a provision is helped to make reformation of an accused through the agency of the court. Even so, the statute affects an offense committed before it was extended to the area. It is therefore a post facto law and has retrospective operation. In considering the scope of such a provision, we must adopt the rule of beneficial construction enunciated by the modern trend of judicial opinion without doing violence to the provisions of the section. And then, my your lordships applied this. So first of all, merely antecedent facts for procedure is not even retroactive. But even if it is ameliorative.
But Mr. Salve, one judgment was cited by Mr. Rohatgi, in which it has been held that 17A is not retrospective, that Justice Banerjee's judgment.
Justice Tejmal Chaudhary is the
I dealt with in the opening. It was on common ground. Counsel said, yes, it is retrospective. And the court, 1 minute please. And the court proceeded on the premise that it is retrospective.